Today's video is about a recent decision of the High Court which provides some clarity on the provision of amendments that could be made to the claims as well as the patent specification under section 57 and section 59. In one of my earlier videos I have talked about the provisions of amendments that are available under the Indian Patents Act and how the courts have interpreted it so far. The recent decision provides more clarity in respect of what type of amendments could be made and what is the scope of amendments that are available to a patentee or a patent applicant. So in case you haven't seen my previous video about section 57 and section 59, I have posted a link of that video and you can go and watch that before this video. So coming to the decision, this is the latest decision of 5th of July 2022 by the Delhi High Court in respect of Nippon A&L Incorporated versus the Controller of Patents. This is in respect of a rejection by the Controller of Patents of a patent application during the hearing, wherein the amendments that were made by the patent applicant were refused, primarily on the grounds of non-compliance of section 59, wherein the controller was of the opinion that whatever changes have been made to the claims go beyond the scope of the original claims. So very briefly, let us just recall what section 59 provides. It says that any amendment which goes beyond the scope of the original specification would not be allowed. Also, if any claim is being amended and it goes beyond the scope of the original claims that were there in the specification, then such type of amendments would also not be allowed. And only amendments that could be made are in respect of a disclaimer wherein you are narrowing down the subject matter of whatever you are claiming, or by way of correction there is some mistake and you are just correcting it, or by the way of explanation, so you are trying to explain a subject matter. So the requirement that any claim which is being amended should not fall outside the scope of the original claim of the specification has been a very contentious issue, and most of the times the controllers would disagree on what type of amendments could be allowed under the provision of section 59. So what happened here was that in the original specification or in the original set of claims, what was claimed was a product by process. So if you can see claim 1, it talks about a copolymer latex being obtained by emulsion polymerization. So it is drafted in the form of a product by process, though it talks about the features of that particular product. Now there were objections that were raised in the examination report wherein the patent office objected that the scope of the protection is not very clear, and thus during the hearing the patent applicant changed the type of claim to claim only a method instead of a product by process. So here you can see the red line version of the amendments that have been made to the claim, and you can see that they have in a way converted the product by process claim to a method claim. However, these amendments were rejected by the Controller of Patents, and the rejections were based on the ground that the new set of claims were beyond the scope of the original claims, as the original claims related to a product claim, while what is now being claimed is a process claim. So in a way they said that the scope of protection is being changed, and it was also said that the process claims were not supported by the description as such. Also, though there was also an objection regarding lack of inventive step, but the controller went ahead and rejected the patent specification based on section 59(1) only, and the controller did not go into the question of lack of inventive step in the invention. So in the appeal, the submissions that were made by the patent applicant was that the amendment is not beyond the scope of the original claims because the original claim contained both the product as well as the process. So now this is a product by process claim. So they said that it is defining a product as well as a process, and so by limiting it to method claim, you are not going beyond the scope of the original claims. The rival contention, however, from the patent office was that by changing the product claims to a process claim, you are changing the nature of the invention as such, and this is not allowable under section 59. To support their contention, the patent office said that patentability of a product by process claim is educated based on consideration of the product as such. So in a way what they were saying was a product by process claim represents a product per se, and thus it has a different scope of protection as compared to a method claim, and thus you cannot consider both type of claims having similar sort of protection. So by this the patent office wanted to say that a product by process claim has a different scope and a process claim as such has a different scope, and thus the original claims had a different scope while the amended claims were beyond the scope of the original claims. So the contention of the patent office is summarized here in paragraph 12, and they say that the conversion of a product claim to a process claim is not allowed under section 59 of the Act. So the High Court went into the analysis of the complete specification and noted that there are two different aspects that are being taught in the specification, and for both the aspects the process for obtaining the particular product covered in the different aspects has been described in complete specification. The court also noted that the original claims were relating to a product by process, and thus both the product as well as the process were captured in the claims as were originally filed. The court also noted that pursuant to the hearing, the applicant had to convert the claims from product by process to process claims so as to provide more clarity and meet the objection of the controller. The court noted that the main objection of the controller was that since there was not a single method claim in the original claims, thus the process claims which are being claimed do not have any support in the original claims, and thus the method claims or the process claims that are now being claimed are beyond the scope of the invention which was originally claimed. So the court crystallized the issue as the contention being that the process which is now being claimed was not claimed earlier, and thus it is beyond the scope of the claims that were originally filed. So the court was considering the question now whether the claims that were originally filed could have been converted to a method claim and could have been considered as allowable under the Patents Act. So the court noted that in the first examination report, the Patent Office itself had raised an objection that it is not clear as to whether the claims relate to a product or a process. So thus now it is not available to the Patent Office to say that the claims did not have a process in it, because they themselves raised this objection that it was not clear as to whether the claim is relating to a product or a process, because both of those were there in the claims. The court also noted that the monopoly that is being granted by a product claim is quite broad as compared to what is granted by a process claim, because the process claim is only limited to the particular method steps, and if the same product is being achieved by different method step, the process claim which is protected would not provide any protection against infringement to the patentee. But to the contrary, if a claim is obtained on a product, then it is a very broad protection in the sense that anyone who makes that product by any process whatsoever would get covered under the claims and would be infringing. So the court was suggesting that a product claim is broader while a process claim is narrower. So in a way hinting towards that whatever amendment has been made was towards narrowing down of the scope rather than saying that the scope was being expanded by the amendment. So to consider the question whether amendment of a product by process claim to a process claim was allowable, the court relied on a decision of the European Technical Board of Appeal, wherein a similar question was before the technical board. There also the claims were amended from product by process to a pure process claim. To decide the question, the technical board had considered the language of the Article 123 of European Patent Convention, which has a similar language as Section 59 of the Patents Act, and the board held that changing of category from a product by process claim to a process claim is admissible under the EPC because it is somewhat like narrowing down of the scope of protection that is available. So the court commented that as long as the invention is disclosed in the specification and the claims are being restricted to that disclosure that is there already in the specification, the amendment should not be rejected. So if you are incorporating some material which is already there in the disclosure, you are bringing that into the claims, that sort of amendment should not be rejected. Also the court relied on a previous decision which is AGC Flats Glass Europe's SA versus Anand Mahajan, which I also discussed in my previous video about Section 59, wherein the court had said that narrowing down of claim is somewhat similar to a disclaimer. So it should be allowed under Section 59. So if you are narrowing down the scope of the claim, it would be allowable. In sum total, what the court said was that if you are narrowing down a particular claim, then it could be considered as lying within the scope of the original claims, provided you are not bringing up any particular matter which was not there in the original specification. So if you are adding some more material into the claim or narrowing down the scope of it, which was already there in the disclosure, then such type of amendments would be allowed under Section 59. So here the court noted that the process which is sought to be brought into the claims was already disclosed in the patent specification. So as such, no new subject matter is being added. Also, you are narrowing down the scope of the claims from a product to a process, and thus this falls within the provisions of section 59 and it is allowable. In view of this, the court remanded back the matter to the patent office for reconsideration based on these principles. So this is all about the decision of the Delhi High Court, providing more clarity on section 59. In case you have any questions, please drop them in the comments box and I'll be happy to answer those. In case you have any specific comments regarding this particular provision or have any doubt, please again drop them in the comments box and I'll be happy to address those. So with this, I end my video. Thank you for your time.